In the rapidly growing multi-billion-dollar cannabis industry, new developments frequently occur in capital markets, investments, M&A, and regulation. In a spotlight interview, Frank A. Segall of Burns Levinson meets virtually with Steven Hoffman, chairman of the Cannabis Control Commission of Massachusetts, to discuss the state of the industry in the Commonwealth and beyond.
There you go. Good morning, Steven.
Good
Mr.
morning,
Commissioner.
Frank.
Well, this is now our third year that Commissioner Hoffman has been so gracious with his time. We have a lot to talk about, and we'll condense it. I will not be Leslie Stahl, and he will not be President Trump. I can assure you of that.
Yeah.
This will be very productive.
I'm out of here, Frank. That's too tough a question.
But what we do appreciate is Steve is not a politician, is a true businessman from his days at Bain and an entrepreneur with venture capital, and has really brought that approach to the commission and has always been accessible to me, Burns and Levinson, our clients, and to others in the industry, and we appreciate that. A lot has happened over the last year besides your COVID beard, which we noticed. But, I thought we could just talk about the landscape in Massachusetts from last year to now first. And the numbers, have really improved. And these are probably, semi-accurate, but when we look at the number of licenses that have now been out there, cultivation, around 50 licenses final, 125 provisional, product manufacturing, about 40, 92 provisional, retail, 91 final licenses, 150 provisional, Boston about 16, social equity, economic empowerment, over 20 approved. It seems like progress has been made. Over a year ago, obviously one of the concerns and complaints that you had been receiving is the time process to get through the system at the CCC. So I was hoping, Steve, you could maybe talk about that, what you've implemented and how you see things continuing to hopefully improve and attract business to Massachusetts.
Sure. Thanks, Frank, and thanks for the kind words. We've been working very hard on throughput. I think we've made enormous progress. The numbers that you mentioned, I think, are partly testimonial to that. We've invested heavily in technology. We built our staff, and we really have focused on turnaround time. And I'm really pleased. We have a 90-day window. Once an application is deemed complete, we have a 90-day window legislatively or legally to act upon that. And we've always adhered to that. The problem was getting applications deemed complete and getting through the intake review. We are now at the point where there's literally no lag. As soon as all four parts of an application have been submitted, we'll do the intake review. If there are still outstanding items, we'll go back to the applicant and say we need these before we can get started. But if it's complete, we start the 90-day clock, and there's no lag getting into that initial intake review. And we've worked really hard on that. So I'm very proud that we've gotten to that point. We have been working remotely, as I think you know, since early March. We have good technology, and we're actually more productive in terms of license processing, working remotely than we were working face to face. I'm not sure I understand that exactly or the reasons for that. But we've been averaging since we went remote about 50 provisional licenses per month at our monthly public meetings, and we're working on our agenda for the upcoming meeting in November, and it looks like it's going to be more or less the same order of magnitude. So, I feel good. We're working hard. There's certainly a lot more applications in the queue, so we're not relaxing. But I feel really good about the progress we're making in terms of processing applications and keeping up with the pace.
Steve, the progress has been great, but there's always hiccups here and there along the way.
Sure.
What's your recommendation to a group that feels that the application is not being furthered along? Where's their real front line of communication? How do they move that through the system?
There is a commission mailbox that is easily accessible on our website. Our director of constituent affairs reviews that mailbox every day and essentially triages it to get it to the right person. All of us, including myself, we are accessible. Our emails, and in my case, my cell phone number is accessible on our website. Reach out to the commission. If you're not getting an answer, reach out to either the mailbox, reach out to me. Our objective is to be completely transparent and open. And if there's an issue, it'll be addressed. I'm hearing much less frequently that things are bogged down, but typically, as I said, when we get a completed application, we do one of two things. Either we send a notice saying the application has been deemed complete and the 90-day window or clock has started, or we go back to the applicant and say we need these additional pieces of information. So there really shouldn't be any kind of lack of transparency, but reach out if there is, and it will be addressed.
In your mind, somebody coming to Massachusetts saying, I want to get into this industry, I've got the location, et cetera. How long do you feel it should take them from filing to final issuance, especially with the pandemic? And I know going out and doing physical inspections is an issue and a concern that can delay the process as well.
Yeah, I mean, it's hard to answer your question because we control part of that process, but we don't control other pieces of the process. So there are kind of three major pieces of it. We can't get started processing a license application, as you know, Frank, until there's a signed host community agreement in place between the applicant and the city or town in which they're planning on doing business. And we have no control over how long that process takes. From the time the applicant starts talking to the city or town until we actually have a signed host community agreement. That is out of our control. As you know, some of the bigger cities in Massachusetts, like Boston and Cambridge and Somerville, didn't issue host community agreements for quite a while as they were trying to work out their own process and make sure that they were working towards equity objectives. That's something that's completely obviously outside of the commission's control. Once, as I said, it comes into the commission as an application where a host community agreement has been signed and we have a completed application, we have a 90-day window to act on a provisional license. And we almost without exception have met that window. Once we issue a provisional license, again, it kind of gets a little bit out of our control because once a provisional license is issued, the applicant has to build out the facility, call us and tell us they're ready to have a final inspection. We go in and do the final inspection. And if everything is okay, we'll issue a certificate, a final license, and a certificate to commence operations. If there are issues with the build out, obviously it takes a while to get those resolved, but we don't control how long it takes from the time we issue a provisional license until the applicant comes back to us and says, I'm ready for a final inspection. We do ask in the application process, how long will it take you to open once we issue a provisional license? And the answers we get back from applicants vary from 2 months to 2 years. So we control the middle part of that, but we don't control the front end and we don't control the back end. And so it is a little bit hard to answer your question. It's going to take a while. It's going to take a while, and different cities and towns are moving at very different paces in terms of, how quickly they're issuing host community agreements. And that's part of the challenge in terms of the time frame of entering the business.
One thing that, and what I like about these fireside chats is that you can go off script. You talked about the community agreements, and we talked about that last year and how some of the towns and municipalities were not really following the regulations, and you didn't have the enforcement powers to do that. How has that changed, if at all, in the last year?
It really hasn't changed, and that's a challenge that we're facing. So we have reviewed most of the host community agreements that have been signed across the state. We believe, as you just said, that there are some issues. I'm not going to paint with a broad brush here. It's not every city and town, but there are some issues in various municipalities across the state. It is our interpretation of the statute that we do not have enforcement authority over host community agreements, that they are private contracts between the city and town and the applicant. That has been upheld. Our opinion on that has been upheld judicially a couple of times. So we did ask the legislature to clarify both what was allowable in host community agreements, because there's some ambiguity there, but also to clarify who had enforcement authority and requested that we be given that enforcement authority. That legislation, I'm pleased to say, was filed. It did come out of committee. Where it's at and what's going to happen to it, I couldn't possibly forecast. Obviously, there's a lot of weighty issues in the legislature these days, and I don't really have the ability to forecast if and when this piece of legislation will advance. But it has been filed and it has gotten out of committee, and I'm deeply grateful to the legislature for honoring our request on that.
That passed. How do you see the CCC working with the cities and towns, or messaging that, hey guys, this is what you can really charge, et cetera, so we don't have things like Fall River, et cetera, happening again?
Well, I'm not sure that the legislation is going to say that we have enforcement authority over what allegedly happened in Fall River. That's clearly
no, of course.
I don't want that authority. Thank you. But obviously, it depends on what the legislation looks like in terms of, again, we ask for two things in the legislation. One is specificity on what is allowable on host community agreements, and then two is the enforcement authority. We'll have to see what's in the legislation, but my hope is the clarification of what is allowable will actually make our enforcement responsibilities easier. Because I really, I don't think a lot of this is malicious. I think that what's going on sometimes is just because there are some issues of clarity in the legislation, and I hope if they're clarified, we won't have too many municipalities that are out of alignment with what the intent of the law is. I really can't speculate on what the range of our enforcement authority might be. We might have the ability to refer things to the Attorney General's office. It's just, we'll have to see what the legislation looks like. But to me, the most beneficial part of this legislation, assuming it gets passed, will be the clarification of what's allowable and what's not, because I think that will get a significant percentage of the problems.
I think that's very important. There are, when you read some of these HCAs, well, many of them are similar, some are not. But if you look at the regs, as you know, it says that, you can't charge more than the 3%. It's supposed to be tied to direct expenses, but it also says it's for 5 years. And many of these municipalities are providing that you have to, not only is it for 5 years, you got to renew it at the end of 5 years.
Auto renew, which kind of it violates the spirit, not the letter of the law.
Exactly. So, was it supposed to be it's a one-time 5-year contract and then you're okay? But that's not how these municipalities are interpreting or even drafting these HCAs.
Again, why I think that if there is clarification in the legislation, this should go away. I don't know what the final form of the legislation, A, if it's going to pass, but B, if it does pass, what the final form is going to look like. So it's really for what we're going to do, other than we'll continue to do what we've done all along, which is we collaborate with cities and towns. We work closely with the Mass Municipal Association. We meet with and talk with municipal officials on a regular basis, and we try to help as much as possible. We have, as you know, several guidance documents that we've issued on issues of HCAs, but also including issues of equity and other things. And we'll just continue to collaborate with cities and towns. The way the legislation was designed was, while we are the only agency in the state that has the authority to issue licenses, the municipalities have a major role in the rollout of this industry. And so we view them as partners and collaborators in terms of getting this done right.
I appreciate that. Steve, before we move off this topic, just last one thing. Should anyone be anticipating any changes to the application process? Has that been discussed? Are you, fine-tuning it, refining it, or adding any new requirements that you think will be coming out?
No, I don't think it's going to change much. We are continually working with our on our licensing portal to make it more user-friendly and efficient. The fundamental change that we've worked on most recently is, as you know, we added a courier delivery license type a while ago, and so we worked with our vendor to put that application in place. We had, for the first time, we allowed applicants to pre-certify. So before they went to the cities and towns to go for the HCAs, we pre-certified them so that process, hopefully with cities and towns, would go more quickly. That required a change to our platform and our software. So we're tweaking it and updating it, making it more user-friendly, but no fundamental changes, Frank, that I anticipate.
And we'll talk about delivery in a minute, but
I can imagine that we wouldn't.
It'll be for more than a minute, I'm sure. But look, this year, the pandemic, it's hit a lot of people hard. Other than Massachusetts that I'm aware of, cannabis was considered essential and an essential business. And, we struggled with that with Governor Baker and his staff, and we weren't considered essential. And it caused a lot of havoc. I know you fought hard for this. Can you share with the audience your, in hindsight, your viewpoint on this? And look, the pandemic has not gone away. If anything, it's getting worse. I mean, and there's always that risk of another shutdown, as dramatic as that might be. And how do we avoid that being classified, being the only state where we're not classified as essential? How does this industry unite with you, working with the CCC? Or do you think Governor Baker has gotten that message and it's not a concern?
I appreciate you starting the introduction by saying I'm not a politician. So I am not a politician. When Governor Baker made the decision to classify recreational marijuana as non-essential, I didn't take stand. It's his prerogative. It's his decision. I did not take issue with that. Whether I personally agree with it or not is irrelevant. I did not take issue with it. It is certainly his authority. What I pushed back on were two things. One is, it is extraordinarily unfair that while the recreational industry was deemed non-essential, they were also excluded because of the federal issue. They were excluded from receiving any kind of funds from CARES Act and other things that other industries, pretty much virtually every other industry that was shut down, got some federal assistance. This industry did not, and that just struck me as fundamentally unfair. Two is, while the governor deemed the recreational industry non-essential, he did, and I'm grateful to him, he did keep the medical marijuana industry going. And we quickly adapted, working with the industry to help those dispensaries operate as safely as possible with curbside delivery, with allowing for telemedicine for initial consultations with physicians. We acted quickly and I think nimbly to work with the industry to make sure that the medical part of the industry operated safely under the constraints of the COVID crisis. When the governor did relax the restrictions on recreational, we did the same thing. And I think what we have shown, and I hope this is going to be part of Governor Baker's thinking going forward, we've shown we can operate these businesses safely, even during the pandemic, that we will take all the necessary steps in terms of protocol, in terms of social distancing, in terms of regulations. We can and will operate these businesses safely. So I'm hopeful if we get to that point, and I hope we don't get to that point where it becomes an issue again, but if we do, I hope we've made a very compelling case that we can and will operate these businesses safely.
No, that's very, very important. Obviously, people have different viewpoints on Governor Baker's stance on the cannabis industry. We are hopeful, speaking as somebody in the industry, we're hopeful that the pandemic does get resolved and doesn't result in another shutdown, which, has far-reaching repercussions beyond just the cannabis industry. But we all need to be sensitive to it because we were the only state that was not deemed essential.
I wanted just one other thing, which, I was deeply concerned that, we are in an early stage of our industry. At the time the governor issued his executive order, I think there were 44 or 45 retailers operating in the state. We're up to over 70 now, 77. But at the time there were only, I think, 54 or 44, excuse me. I was deeply concerned that some of them wouldn't make it through the shutdown. And while I'm not trying to understate the economic and personal consequences that someone had to deal with because of the shutdown, the fact is they all emerged. All 44 or 45 that were open before the governor's executive order emerged and are still open now. And I'm really, really happy about that. I'm surprised, but I'm very pleased about that. I applaud the resiliency of the licensees to get through it. So I hope we don't have to deal with it again. But I'm grateful and pleased that all open retailers made it through this shutdown.
No, I appreciate that. Steve, there are a number of obviously companies and industry leaders watching today. We have, I don't know how many are online right now. We have over 200 people who have registered for today's conference. For those who are industry leaders, consultants in Massachusetts, how did you find the experience working with those leaders in dealing with this pandemic issue, and what recommendations do you have for the industry with respect to collaboration with the CCC on such hot issues?
Yeah, I mean, we're very careful. I said we as a commission, and me personally as chairman of the commission, did not and will not attack the governor's decision. I truly believe that it's his prerogative. You can agree or disagree with the decision, but I truly believe it's his prerogative and his authority. My suggestion, and it's just that, is collaborate with us on protocol and safety. I believe that at the end of the day is, I think there was a shift as we got into this from, trying to, draw this fine line about what's essential and what's not essential, which I think is a really difficult line to draw. And it's judgmental and it's not linear logical. I think thinking evolved from what's essential and what's not essential to what can we do safely, and how do we keep our economy and parts of the economy going in a way that's safe under these circumstances. And to me, that is the argument. That is the argument that the industry should make with us. We collaborated with them in terms of the rules that we came up with once the recreational stores reopened about how to operate safely. And to me, I think they showed the value of collaboration between ourselves and the industry, because it wasn't about whether Baker was right or wrong. It was about, we can operate this business safely, and we're committed to do so. And that, to me, needs to continue. That's the collaboration. I will not participate. The commission will not participate in any, assault on whether the governor has the right or the authority to do this, whether he's making the right decision or not. That is not our role. But we are able to and have and will continue to collaborate with the industry on operating these businesses safely.
I appreciate that. So that's a great segue into the hot topic of the day of the last month or so, is delivery and also changes to the rules and how that process should be in cooperation with the industry and with their input. So just to summarize for those not in Massachusetts, we have a brick and mortar system in Massachusetts that allows for a courier system to deliver medical. And what has been proposed by the CCC are regulations to basically develop a system of delivery for adult rec, a wholesale system where you can buy wholesale, repackage, and deliver. And this has created tremendous concern from the brick and mortar retailers. Towns have spoken out, and it actually was supposed to have a vote today, which the commission has postponed. Basically, and Steve is promulgating these regs for those in the audience. This enables economic empowerment, social equity candidates to have a 3-year exclusivity and to get up to 2 licenses, which would enable them to have 2 warehouses to buy, repackage, and sell directly to consumers. On the one hand, you have the economic empowerment candidates saying this is another opportunity for us to prosper in this industry. On the other, you have the retailers and dispensaries saying this was not what we signed on to. This is a game changer. It's not a rule changer. It's going to create economic impairment to us, and many of us are economic empowerment, social equity candidates. So while you're helping one side of us, you're hurting the other. And the municipalities have come out particularly saying this creates uncertainty as to tax revenue and having a car drive by a dispensary and making a sale that we're not capturing. So you've obviously received a lot of comments on this. What was behind the thinking of making this dramatic change? And do you feel that, it was properly handled in the sense of there was enough time initially for public comment. There was enough input. Should there have been more bringing in the industry and not working collaboratively, but getting their response in advance or suggestions? Maybe you can tell us about the genesis of this first.
Yeah, I mean, thanks, Mike. The genesis, this actually goes back to the very early days of the commission. So in the winter of 2017, 2018, when we drafted our original regs and then had public hearings and public comment, we actually had delivery as one of the license categories back in the winter of 2017, 2018. We got, as you will recall, a lot of pushback saying essentially walk before you run. And we listened, and we did defer delivery for a couple of years, but it's been on the table for a long time. So I kind of reject the notion that this is new. It isn't. It goes way back, and we've been talking. Everything we do, as you know, is public. We have the open meeting law, but we also have a commitment in our mission statement that we honor daily to operate transparently. So people can and do all the time disagree with things that we do. But we do them in the open and transparently, and we've been talking about delivery for a long time. This particular round, we have gotten a lot of feedback, and unsurprisingly, it is not consistent. So we have a lot of people pushing for the kind of delivery that we're talking about. We have the consumers asking for it. We understand the industry is imposed, but I also would ask you not to characterize it as uniform. There are plenty of cities and towns that we've heard positive things from. There are plenty of retailers that we've heard positive things from. So while there's been a lot of noise, it isn't quite as uniform, I think, as you reflected. The process that we followed in this round of regulations adheres to both the law of regulation development as well as to our philosophy of openness and transparency. So we had draft regulations done several months ago. We had a public hearing. We had public comment period. Based upon that public comment period, we made some changes, including adding this new category of delivery. We could have at that point gone forward and voted on them, but we said this is brand new enough. Let's take a pause and open this for public comment, which we did. We had 2 weeks of public comment. We got well over 100 public comments. I will tell you, unsurprisingly, there was not alignment in terms of the public comments we received. They were all over the place, but that's fine and to be expected. We then met last week and discussed the public comments. We made some changes, including to the delivery model that we're talking about. And we voted to go forward and embed them in regulations, and we were going to vote on them today, as you pointed out. As soon as we had the meeting last week, though, and voted to go forward, we heard an enormous number of, we got an enormous number of statements saying people felt like they didn't, the 2 weeks that we gave them for public comment, which was not legally required, but we did it because we wanted that input. We heard that wasn't enough. We heard that people wanted the opportunity to not just submit comments in writing, but to be listened to, be heard by the commission. And we said, fine, we'll do that. So we essentially are going to take an extra month. We are going to have a public hearing on November 13th. And we're going to give people what they asked, which is more time to think about it and to respond, and the ability to speak to the commission directly. I think that is totally consistent with the way we have always run the agency, which is to take our time, not rush, listen, try to be as careful and thoughtful as possible, try to do the right thing, understanding that no matter what we do, people are going to disagree with it. I'm okay with this. The deadline we had of putting things in place today was a self-imposed deadline. So pushing it out a month, to me, is it doesn't have any cost to it, and it's the right thing to do.
Do you feel that this warrants more than a public hearing, maybe a committee of industry from both sides with the CCC and really analyzing the economic impact or the concerns? I mean, the concerns you're hearing consistently are this is going to be dominated by an Amazon. There's no limit on the cars. There's no limit on the radius. The technology companies like Drizzly, who are incubating these delivery systems are really going to, have arrangements that give them control. Those are a lot of the consistent, besides the economic impact of taking sales away. Do you feel that warrants a deeper dive or investigation into this?
Well, I think we've talked to the industry a lot, Frank. Obviously, they're not shy, and all four of the commissioners have met with the industry on multiple occasions on this topic. So I feel like they've had a chance to input. I really do. Two is we are just as committed as the industry is. We're not going to let this business be dominated either on the wholesale side or on the platform side. We talked about that extensively at our meeting last week. We made some progress there. We're going to, solicit more input on that. I would love to hear what people have to say about that in terms of the public hearing that we're going to have on the 13th. So we have the same objective as the industry in terms of not allowing for domination on the wholesale side or on the platform side. And, I'm confident we'll get that right and we'll prevent that from happening. So I don't necessarily agree with that. I agree with the concern. I don't agree that it's unaddressable or that it's inevitable. But the public comment period in the public hearing, they can serve two purposes, and I hope they serve both. One is I'm more than happy to hear about why we're making the wrong decision or why people think we're making the wrong decision. That is certainly part of the process, and we listen. We really listen. But they can also be constructive as well, which is to the issue that you just raised about, dominance of a platform or dominance of wholesale. Help us figure out how to prevent that. We think we have some pretty good ideas, but be constructive, and help us think about how we can prevent that. So, I think the month is sufficient. As I said, people have been talking about this issue for a while. We have met with all constituencies on this issue, at least for several months. I feel like we have enough information. I think the month gives people even more time to do it. I don't see any need or benefit to extend it beyond the month. But I think the month is not just for show. The month is we want to listen. We want to hear what people have to say. We welcome their criticism, but we also welcome their suggestions.
When in your mind, or what is the timeline that you are trying to establish where regs are promulgated and somebody can actually get a license? And how long do you see that process?
Those are two separate questions. So in terms of the promulgation, we are having the public hearing on the 13th of November. And I believe November 30th is essentially the replacement for the meeting we were supposed to have today, which was to vote on the final regulations. That meeting will be pushed back a month to the 30th of November. It takes a little while after that to go through the Secretary of State's office and have the regulations promulgated, but that's the time frame. It'll take us a couple months to update our application portal for if we go forward. And I'm underscoring if this is an open issue. This has not been finalized, but if we go forward, it'll take us a couple months before we can start processing applications. So we'll work on that right away if we go forward.
Have you? What have you seen in other states that are trying to grapple with this? Did you? California is a very robust delivery system, but it's not direct like this is.
This is unprecedented. I'm more than willing to acknowledge that. We certainly looked at the other states and saw what they were up to. We feel, and again, we voted on this, but we agreed to push things back for a month before we finalize it. So everything I'm saying is still subject to finalization. But we voted because we feel this was an important thing to do to advance equity in the industry, to respond to consumer preferences. We feel it's the right thing to do. We don't think it's a simple decision. We understand it's contentious. We understand that there's differences of opinion on this. So, we're not doing this lightly and we're not doing this obliviously. But the decision we made when we said we were going to go forward with this was based upon our belief this was the right thing to do to advance equity in the industry. And as you know, we are the only state in the country, other than now Illinois, that came after us. We are the only state in the country that has equity provisions in their legislation. And so the fact that we're doing something that other states have not done perhaps isn't surprising because they don't have the same statutory requirements in terms of equity and giving back to disproportionately impacted communities that we have. It's not easy. It is not easy. We believe it's the right thing to do, however, at least pending the public hearing we're going to have on the 13th and pending our subsequent discussion based upon the input we get on the 13th.
So, Steve, sticking with social equity, moving off the delivery, we've had our Leslie Stahl Trump interview there.
I'm still here. I haven't left.
Well, you're going to leave your own house. But what are some of the other ideas that the commission is perhaps thinking about that you could showcase with us or pre-shadow on social equity, economic empowerment, to continue to improve that in the Commonwealth? I mean, one thing that we've talked about in the past is, capital is a real problem, obviously. I personally think that there are ways to have capital structures, that perhaps don't require majority control, but still are significant stakes that might bring more capital into the market. For example, what kind of things are you guys discussing at the CCC to create beyond delivery more enhancement, and particularly dealing with the capital issue?
Yeah, so I'm proud of the progress we've made. I say that acknowledging we have a long ways to go. We are nowhere near where we need to be or want to be on this issue, but we have made progress, as you pointed out in your introduction, in terms of the number of social equity and economic empowerment applicants that have received licenses. Substantial improvement over the last 12 months, and that's great. But again, I say that acknowledging that we have a long ways to go and a lot of work to do. We'll continue to tweak as much as we can our regulations. We've done things, as you mentioned, with respect to exclusivity periods, with respect to prioritization, with respect to training, and we'll continue to enhance those efforts. But I certainly agree with your assessment that the biggest struggle is with respect to capital availability to these applicants, and I'm pretty frustrated that we aren't further along on that than we have been. I've mentioned before, Illinois was the next state after us to legalize recreational marijuana, and I'm proud of the fact that if you look at the law, it looks like Massachusetts law in terms of equity and social justice mandates. They clearly modeled it after the Massachusetts law, and we should feel good about that. But they did one thing that we didn't do in our law, which is they took, what we call the excise tax version of the 20%, and designated a part of it to go into a fund to help with social equity and economic empowerment applicants. We have not done that. I worked closely with the legislature. We requested that they file legislation to do that. I am very grateful they did. Senator Chang Diaz, who's the co-chair of the Cannabis Policy Committee, filed legislation to essentially divert a piece of the excise tax into a low-interest fund for social equity and economic empowerment applicants. Again, just like the host community agreement legislation we were talking about, it came out of committee. I don't know if and when it will be acted upon, but I'm grateful that there was follow-up on the legislature. That being said, I don't think it would be responsible of me or the commission to just say, okay, well, hopefully that legislation is going to pass and we'll wait until it happens. So I applaud what you were saying, Frank, and my intention is to, as soon as we get done with this round of regulations, which is now going to take us a month longer than I originally expected, to create a working group from the industry, from the community, from the government, and let's figure this out. I know people like you have been thinking about that. I know some of the banks that are involved in this industry have been thinking about that. I know the industry association has been thinking about creative ways to do it. I think it's time to let's just sit down and roll up our sleeves and figure out how to do it, because I think it is doable. I am still going to work to try to get a public funding part of this as part of the solution, but I think that we've got to work simultaneously on how do we do this privately. And so that is my intent, to convene the right group of people as soon as we get done with this round of regulations. Because I will continue to make progress on social equity as we have over the last 12 years, but really cracking it is going to take cracking the funding issue, in my opinion.
Yeah, no, there's no question. Look, funding is difficult enough, and we're going to be talking about that later in the day with respect to with a panel of 8 venture capital firms. But it's certainly when you have more regulation and it requires you to give up control, to an applicant, then it's harder to source that capital. There's no question.
I understand. You mentioned I came from that world, and so I completely understand.
Right, exactly. So Steven, what about we talk about what other states are doing? Where do you feel we are in the supply chain? What's coming online, and what do you see in the next couple of years as an optimum level of retail stores, cultivation, and do you feel that we have any real voids right there right now?
Yeah. No, it's a good question. We talked a little bit last night. There's no question that that the number of retail stores, and the demand that has created has outpaced the cultivation capacity in the state. There's no question about that. We are catching up. You mentioned the number of cultivation sites already open. I will tell you that on top of the ones that are already open, there are 112 provisional licenses that have been issued to cultivators. That are, months or maybe a year, but in the process of opening and adding to the supply in the state. So I think this is an issue that will get corrected relatively soon as cultivation capacity catches up to retail. We have been focused from day one, obviously trying to find that balance, make sure there's adequate supply. But if we're going to err, we're going to err on the side of too little cultivation rather than too much cultivation capacity. And if you look at other states, that's a big problem. If you look at Oregon, you look at Washington, they have way too much cultivation capacity. They have dramatic excess supply. It's caused prices to plummet, which doesn't make entrepreneurs happy and certainly doesn't make government or legislatures that are counting on tax revenue happy. But the biggest problem with oversupply is that's where diversion comes from. If you got too much supply and you can't sell in the legal market, you're going to look at other outlets, and we cannot allow that to happen. So we've been trying to get that right. Our relegation system, I think, is going to help that. So I'm more concerned about oversupply than undersupply. But I do recognize that we're a little bit behind. But as I said, I feel pretty good about the fact that we have 112 provisionally licensed cultivators coming online, hopefully in the next few months or certainly in the next year. So I think you'll see more balance going forward. With respect to the number of retailers, we decided early on we were not going to cap the number of retailers. Cities and towns are actually, in some respects, putting on effective brakes on that. Most of them have limits in terms of the number of retailers. Either they banned them outright or they have limits in terms of the number of retailers they're going to allow in their cities or town. So I don't think we need a statewide cap. Right now, I think we have 77 retailers open in the state. I think we can see 200 to 250 and have comfortable amounts of revenue for all of them. I think if we get much above that, we'll see. But based upon looking at other states and kind of where they're at, and we did, as we had KPMG do a study for us to respond to a legislative mandate about looking at alternative tax structures, and they built a forecasting model as part of that. They came up with a 250 number in terms of the forecast steady state number of retail stores. That seems reasonable to me.
Do you recall what their forecast was for the need for cultivation to service that 250?
We didn't look at that particularly because their focus was, what would be the economic consequence to the state of alternative tax structures. So right now we tax at retail as a percentage of sales. The legislation required us to look at alternative structures, including taxing on potency and taxing on weight. So, but the focus of their work was retail demand. They didn't really go back through the supply chain. It's something we're going to continue to look into right now. As I said, we have 112 coming online. I believe that'll be sufficient, but we'll keep looking at it. And I don't think we're that far behind right now. We are behind. I'm not denying that. But I think with the flow that we've got in our licensing queue, we'll be okay there. One of the things that I said last night, and I've learned is kind of a humbling lesson, is that I can't give out a license if somebody doesn't apply. The only licenses we can give out to are those that apply. I'm glad that we have a significant number of cultivation applications. Probably took us a while to get enough, but I think we've got sufficient. Once the ones that are currently in the queue come online, I think we'll have sufficient capacity. And we've given out a total of 460 provisional licenses across all categories right now, but there's still a large flow of incomplete or partially submitted applications behind them in the queue. So we're not done. This 112 cultivation that are in the provisional license stage, there are many more behind them. So I recognize the issue in the short term. I'm not concerned about it in the long term. What I am concerned in the long term is making sure we don't end up in an oversupply situation like some of the other states.
You mentioned we're a no cap state. You don't necessarily see that changing. The market kind of addresses it. Although if you look at Colorado, it's like Starbucks, one on every corner.
Yeah, but the market addressed it. As I said, the other thing that addressed it were the cap that many cities and towns have put in place.
Following that, as industries develop, typically what you see is consolidation. Some not, the strong survive, the weak don't. But that doesn't mean they should necessarily close their doors. Could you see the rule of three being lifted in the future to address those kind of concerns?
It's certainly not on the table right now, and I'm not going to forecast that. That's a pretty important, the diversity of the industry, not just in terms of ethnicity and gender and so forth. The diversity of the industry in terms of small and large players is sacrosanct. And we're not going to stop making sure that's the case. So, I'm not going to speculate on what we might do in the future other than we are going to ensure that there is room for small players in this industry. I have nothing against bigger companies. I've worked for many of them myself. I have nothing against bigger companies, but there is going to be space for small players in this industry. That's the one thing that is not going to change. What tweaking we'll have to make of our regulations, if any, is speculative at this point, but we're going to make sure there's room for the small players in this industry.
Well, and also I know you want to foster the social equity, economic empowerment players. Right. What's interesting is there's no uniformity among cities or towns or even in our own CCC regs about, seeing those licenses transferred down the road. Some cities and towns are saying now you can only transfer to another economic empowerment candidate, right. But that's not the case, generally. So within a few years, when that exclusivity period is up, you could see transfers to major players.
No, sure. And as I said, I got nothing against big players. We are, we're going to make sure that there's room for small players. Right now, the cap of 3 licenses per category is in place, and it's not on the table to change that. But I'm sure you're right. There will be some consolidation, but it will be within our cap limits.
I understand that. No, what I was addressing is, has there been thoughts as to limitations on the economic empowerment licenses that prevent transfers down the road? Like the city of Boston just came out with regs that say you can only transfer to another economic empowerment candidate if you got a license.
Yeah, I mean, I'm not going to comment on municipalities and how they're doing it. We have very explicit, requirements on caps on how transfer occur, and we also have that if you are an economic empowerment applicant and you sell to a company and end up that the economic empowerment applicants no longer have control of the business, no longer have a majority of the equity, they lose their status. It's less important on an ongoing basis, losing your status because you've already gotten the benefit of being front of the queue and the exclusivity period, but you lose some other benefits in terms of reduced license fees, reduced metric fees, and so forth. So we've addressed this issue at the state level in the commission. What local municipalities do is their business.
Yeah, but at that point in time, they're probably sitting on a beach somewhere, so they may not care about losing the status.
I understand that.
Well, as we wind down, Steve, what are your thoughts with respect, not with respect to the election, but with respect to the industry? Post-election, you obviously talked to other states. I mean, do you have any kind of forecast with respect to like the Safe Banking Act or deschedulization? Anything that you can share with the audience?
No, I have no insight on that. I know as much as everything else in Congress knows. I'm rooting for the Safe Banking Act because I think it's just important for the safety of the industry. But I don't really have a forecast on what's going to happen at the federal level. I certainly have no forecast about what's going to happen next Tuesday.
Yeah. No, that would be a whole nother hour of conversation, if not more. Well, look, right, Commissioner Hoffman, we always appreciate your candor, your time, and your efforts on behalf of the industry. We know the next month will be very interesting, for the commission and the industry as they have some deep discussions, particularly on this delivery topic. And, as I said, we've come a long way in a year with respect to opening up licenses, making improvements, with a nascent industry, and we are certainly one. There's always a lot of issues that have to be confronted. And, I appreciate the effort you and your team are making. And thank you again for joining us today.
Thank you, Frank. It's always thank you for those kind words. It's always a pleasure being here. And I actually very much look forward to having this conversation in a year and hopefully being able to talk about the progress we've made in the 12 months previously. So I look forward to our next conversation, and I certainly look forward to hopefully doing it in person.
Yes, I was going to say that. Thank you. So be safe.